All rise. Okay, a couple of you. I also wanted to say that. You can be seated. Welcome to Law for Creatives and Weebs and Creative Weebs at Sakura-Con. And do you know how long it takes a lawyer to watch an anime episode? 23 minutes to heal you for half an hour. Welcome to my panel. Before we get started, there's a few quick disclaimers we have to go through first. I am a lawyer, but I'm not your lawyer, and nothing in this panel should be considered legal advice. That's something you hear a lot from legal people on the internet. The reason for that, long story short, is because attorneys owe certain ethical duties to their clients or prospective clients, and in order to avoid that, it's important that we be very clear about where everybody stands. So any specific legal questions should be addressed to a lawyer licensed in practicing your jurisdiction. This panel will not be comprehensive. I'll try to cover as much as I can. We do have limited time. And more importantly, law does vary significantly on a state-by-state basis. I am admitted in Washington, and it's also where I practice, so that'll be the focus of this presentation. The panel is current to the best of my knowledge, excuse me, but the law is constantly changing, especially in areas such as intellectual property, so I can't guarantee that it'll be completely current or accurate. And on that note, all opinions and errors, not that there will be any, are mine alone and will reflect the views of my employer. Now, my name again is Mailer, and you may know me from some of my illustration work or from some of my previous panels at various conventions. However, I'm also a lawyer who is not your lawyer. Been practicing for over 10 years in a variety of subject areas, and I've also been illustrating for more than 20 years. So it's both an attorney and a creative. I think that experience has really helped me appreciate that some basic legal knowledge is important for everyone, but especially for artists, VTubers, makers, creative people in general. But at the same time, there's often a lack of access to legal information. It leads to certain misconceptions, misunderstandings, and this panel will try to address some of those. Hello. Find a seat anywhere. Thank you for coming out at 10 on a Sunday. I haven't seen this many hungover weeks since law school. So this panel will be a very, very high-level view of a few legal concepts that are relevant to fans and creative people, including copyright and contracts. We'll address some common legal misconceptions. We'll talk about when and how you might wish to consider getting a lawyer and how to make good use of them. And because we do have a lot to cover, I do have to ask that questions be taken at the end. So, first is copyright. We'll cover topics such as what is copyright, getting a copyright, DMCA notices, fair use, cosplay, fan art, commissions, licensing, public domain, and because it is a year 2026, we do have to talk about AI. So, what is a copyright anyway? Copyright is an exclusive legal right under federal statute to do certain things with a work, such as copying the work, making derivative works, selling, renting, performing, displaying, or playing the work. One important right that is not part of copyright is the right to be attributed. Nothing in the statute references crediting or sourcing, so plagiarism is unethical, but it's not necessarily copyright infringement, although the copying itself might infringe on copyright. Conversely, sourcing or crediting is not a defense to copyright infringement. So if you've ever seen a video that says, I am not the creator of this, all rights belong to the original creators, that unfortunately has no bearing on whether a copyright infringement exists. Now, how do you get a copyright? There are a few requirements that are again laid out in statute, and those include original expression, meaning that basic facts, historic facts, maps, phone books, and so on are not protected by copyright. Abstract ideas and concepts are not protected, only expressions of those ideas. Single words and short phrases generally don't have the level of originality required to be eligible for copyright. And finally, sans affair, which is a fancy French word for like standard tropes, are not protected by copyright generally. Another requirement is, in order to have a copyright, there must be a human author, works produced by animals, and this is actually from a case where a monkey stole a guy's camera and took a selfie, and that monkey's name was Naruto. I'm not joking. But that photo was found not to be eligible for copyright because copyright does require a human author, and similarly, works produced by AI are not eligible for copyright for the same reason. Another requirement is fixation. To be eligible for copyright, a work must be fixed in a tangible form, written down on paper, saved in a computer's memory, things of that nature. One requirement that does not exist is registration. And there are reasons to register copyright, which we'll get into later. But since the Copyright Act of 1976, registration has not been required for a copyright to exist. The right automatically vests in the author once all of these requirements have been met. You should also keep in mind that more than one copyright may apply to a work. For example, if you take a song, the composition, the lyrics, a particular recording of that song, and a music video of that song might all have separate copyrights, which is a lot of fun when you're trying to get permissions. Now, one example of copyright that may be of interest to some of you is cosplay, an example of which you can see on the screen. I wonder who that guy in the middle is. Now, you might be wondering, is clothing subject to copyright? Because it has both some artistic elements as well as some useful elements. And the Supreme Court has ruled that clothing is copyrightable only if it has pictorial, graphics, sculptural elements like the pattern, the core, that can be separated from the clothing for practical use. Things like the basic dimensions, where the holes in the clothing are. And there is a case that a costume of a banana can be copyrighted in the same way that you could copyright a statue of that banana. Now, practically speaking, I do have to note that a lot of cosplays may potentially infringe on the copyright of the character they are portraying, since a cosplay already embodies a copyrightable character design. I mean, that's kind of the point of dressing up as a character. This is why it is important to pay attention to copyright holders' terms for fan works, which we will cover later. So we mentioned registration, and you don't have to register a copyright to have a copyright. So then, why would you register a copyright? One reason is that it is required in order to enforce a copyright. It's a prerequisite for bringing a copyright infringement lawsuit. Registration, if it occurs before the infringement, opens up the possibility of statutory damages. Those are damages provided by statute without the need to show that actual economic harm occurred. And this is important because statutory damages for copyright infringement can range from $200 all the way up to $150,000 per violation, which means that it can add up pretty quickly. There have been cases where people have been hit with $675,000 judgments for torrenting a few songs. So it is not exactly common, but something to be aware of. Now, how do you register a copyright? That can be done online, at least when the government isn't shut down. There is a fee ranging from $45 to $500, depending on the type of the work, and groups of works can be registered together in order to spread out the cost a bit. So we talked a bit about enforcing copyright, and that can happen in a few different ways. There's a few different kinds of violations that are possible, such as direct infringement, actually directly copying the work or infringing on one of the other exclusive rights guaranteed by copyright. There's also indirect or contributory infringement, which is where someone invites, aids, abets someone else in infringing on copyright. There is an important limitation to that, and this is a Supreme Court case that came out just a few weeks ago, but internet service providers are not responsible for their users' infringing activities just because they know about it in the abstract. Something more is required. Indirect infringement is only possible if the person actually facilitated or invited direct infringement. So that is an important limitation on indirect theories of infringement because, otherwise, if ISPs were liable for everything that their users do, you can bet they'd be cracking down a lot harder on torrenting and other infringing activities. Now, for a copyright infringement lawsuit, there's a few remedies that are available. Those include damages. We talked about statutory damages, but there's also disgorgement of any profits that the infringer made from copying the work. There can be injunctive relief, which is essentially a court order to do or not to do something. For example, a court order to stop infringing, to destroy all infringing copies, and so on. Sometimes there can be criminal liability for copyright infringement. That's usually only in the case of large-scale commercial piracy operations, and that's something we don't really have time to get into. But one form of copyright infringement, which many of you, I'm sure, may be familiar with, is the DMCA, or Digital Millennium Copyright Act, takedown and notice and takedown procedure. This is a three-step process. First, if a copyright owner or their authorized agent sees that a work infringing on their copyrighted work has been uploaded to a user-generated content website, such as YouTube or so on, they can submit a takedown notice to that website. The website must then promptly remove the allegedly infringing work and notify the original uploader. This is a condition of the statutory safe harbor without which they themselves could be sued for that infringement. The second step is if the original uploader has good faith belief that the work is not infringing, then they may submit a counter notice. And this constitutes consent to be sued. You have to provide your personal information and consent to be sued in the local federal district court. Upon receiving a counter notification, the website must then restore the content within 10 to 14 days, unless the original DMCA notice sender sues the uploader. This is what we call calling someone's bluff. And usually it doesn't come to that, but there are cases in which it has. For example, there's a very recent case. Some of you may be familiar with the VTuber company Cover, which produces the VTuber group Hololive. Now, Cover recently issued a DMCA takedown notice against the YouTube channel that was uploading some unfavorable clips of Hololive talents. The allegation in that case was that the clips copied or made derivative works of Hololive talents, thus violating Cover's copyright. The channel, the original uploader, brought a counter notification, which again requires the channel to be restored unless Cover brings a lawsuit, which it did. And so that case is going on now in California Federal District Court. I do want to note that this case is still very early on. It's still developing. My initial impression is that it's possible there, depending on the facts, it may be a viable fair use defense, which we will turn to now. Fair use is a term you might have heard thrown around. And just to explain what it is, fair use is an affirmative defense to copyright infringement that courts evaluate using a four-factor balancing test. First, being purpose and character. Is the infringing word transformative? Does it change the original and add a new meaning or message? For example, does it make a parody of the original work? Does it comment or critique the work? Is it for educational purposes? Second is the nature of the underlying work. Is it fact or fiction? Factual works are, well, if the original work that was allegedly infringed on is factual in nature, then the fair use defense is more likely to succeed because, as noted earlier, factual information already has less protection under copyright. Third is the amount and substantiality of the copying. Did the infringing work take more than necessary to achieve whatever transformative purpose was identified in the first prong? Or did the copying go to the heart of the work? Fourth is market harm. Could the infringing work substitute for the original and thus decrease its sales? And this is a balancing test, meaning no one factor is determinative. You may have heard online that say, I'm giving away this work for free, so it's definitely fair use, and that's not necessarily true. Market harm is one factor in the fair use test, but again, no one factor is determinative. Well, let's go through a few examples of fair use, and one of those would be parody songs. An example of which you can see here.
You know it's kinda hard when you don't know Japanese, and subject isn't cool, cause he's such a fucking weeb. He may not have a clue what he's trying to say, but that don't stop him from watching Christmas every day. So his translate this clever babe. You know he really doesn't get it anyway. He's gonna watch your stream and post some memes. He's not okay. He's not okay. So if you don't know how to speak me on go, at least you know you can all go and go. The world needs we up new, so hey, watch out and see.
And what do you think that guy is and why he keeps showing up in this panel? Now, parody songs are an example of a type of work that has been recognized by the Supreme Court as being fair use. The reason for that being, if you look at the purpose and character prong of the test, parody comments on or critiques earlier work, which is both transformative and a social benefit. I mean, imagine if people had to get a license for work just to be able to comment on or critique. They would allow the original author to basically suppress any criticism of that work. In addition, looking at the market harm prong, parody, because it does not substitute for the original work, it doesn't meet the market harm prong of the test. Criticism could well harm demand for the original work if the criticism is devastating enough, but the Supreme Court has recognized that this does not produce a harm cognizable under the Copyright Act. Another example of fair use, which you might be familiar with, is Google image search. There was a case where a photography company sued Google for allegedly infringing on their copyrighted photos by having thumbnails of them in Google image search. And the court in this case held that Google image search transforms pictures into thumbnails, which serve as identifiers for websites. So it's a different use, it's socially beneficial, it's transformative, so the purpose and character prong was met. On the market harm prong, the court held that thumbnails do not substitute for full-size images in the market, and thus the court found that Google image search was fair use, which is a big relief for anyone who's needed to find pictures to use in a PowerPoint presentation. Now, one question you might be wondering is fan work, fan art, fan fiction, things of that nature, is that fair use? And the answer to that is a word that lawyers love to use, which is maybe. There was a case where some fans of Harry Potter made this reference book, and J.K. Rowling pulled a J.K. Rowling and sued those fans. Well, her publisher did. But the court found that the reference book was transformative. However, the court found that because the reference book took too much, that's amount of substantiality, it took too much from the original books, it didn't qualify as fair use in this case. I do want to point out that many intellectual property holders, such as Cover, It's All Alive, Team Shanghai Alice, it's Toho, Cygames, Uma Musume, these rights holders publish fan work guidelines. For example, for Cover, you're not allowed to use their work in a way that's defamatory, you're not allowed to make commercial use of the work. For Cygames, you're not allowed to draw adult fan art of the Uma Musume characters. and you can use those guidelines to manage your risk. Now let's talk a bit about works for hire. Has anyone here ever commissioned or been commissioned for art? Okay, few of you. So, copyright, as we discussed earlier, is owned by the author, and the fact that someone else paid the author generally doesn't result in a transfer of copyright, unless one of two things is true. One, the parties explicitly agreed to the transfer by contract, which we will cover, or two, the artist was an employee of the payer. What that means is that the payer controlled the manner and means of doing the work. Basically, the test is trying to get at, was this kind of a one-off commission, or is the artist's regular job working for the payer, like say you work at an anime studio or something. Now, one example of this is you may have heard about some controversy a few months back with the service Sked. Has anyone here used Sked before? Okay, we got one person, not bad. Sked is a service where people can commission works from mostly Japanese artists under certain conditions, one of which is that creators expressly retain the copyright in their own work. What that means is that clients cannot control when and how creators post the work, and it doesn't mean that Sked is not intended to and should not be used for any art requiring secrecy or exclusivity, which that comes as a surprise to some people, but it shows the importance of reading the terms before agreeing to anything. And speaking of reading the terms before agreeing to anything, talk a bit about copyright licensing. Now, a license is a permission to perform some or all of the exclusive rights involved in copyright, which may include reproducing the work online, displaying, exhibiting the work, printing, merchandising, derivative works, and so on. A license can be written to be exclusive, meaning only the licensee can use the IP, or non-exclusive. It can be worldwide, it can be in a particular area, it can be perpetual forever, or for a limited time. One example of copyright licensing is the license for Super Dimension Fortress Macross, an anime series from 1982. Now, the original rights holders licensed Macross to a company called Harmony Gold, and that was an exclusive license that was worldwide except for Japan, meaning that Harmony Gold had the exclusive right to use the Macross IP everywhere in the world outside of Japan. The original rights holders were not able to use the Macross IP in those areas, and for that reason, because Harmony Gold chose not to do anything with the Macross license, Macross was not seen legally in the West for many years. So that's kind of an example of why it's important to be cautious about how you draft a license, what rights you're giving over. One form of licensing that's particularly important to maybe some of you, is cover songs. Just curious, has anyone here done a cover of a song? Okay, about one person. So cover songs are subject to a compulsory license, meaning that you are allowed to make a cover. The original rights holder cannot stop you from making a cover of their song, provided that you pay the license fee, which is set by statute at 9.1 cents per download or 9.1 cents per song on a physical album. An important exception to that is that audio streaming platforms such as Spotify do cover royalties on the user's behalf under the Mechanical Licensing Collective, although for YouTube, that requires a separate synchronization license, so it's a bit different there. Also want to point out that there are copyright collectives such as BMI and ASCAP that own rights to a lot of different songs and sell blank licenses for the whole catalog to places like radio stations, restaurants, conventions, events, anyone needing rights to a whole bunch of music. Another type of license is actually copyleft, which is a term for a few standard licenses that allow the public to do certain things with the work with the condition that they flow down to derivative works. They apply to any new works made under that license. So examples include the GPL General Public License or Creative Commons, which this presentation is actually covered by. And these licenses allow the author to put the work out in the open, but retain some control over it. So for example, the Creative Commons license this presentation is under does allow to be freely reposted with credit to me and not for commercial use. And because the license flows down, and it does continue to apply to any derivative works people make of this presentation. So let's talk a bit about public domain, which is another term you might have heard used in a few places. To get to public domain, first we have to talk about the duration of copyright. Copyright lasts either the life of the author plus 70 years, or for works for hire, 95 years from publication, or 120 years from creation, whichever is earlier. Works from before 1978 are subject to different rules. We don't have time to get into that. But after a copyright expires, work goes into the public domain and becomes free for anyone to use. Mickey Mouse is an example. He just entered the public domain in 2024. As is Winnie the Pooh. And that is the reason for, did anyone see that Winnie the Pooh horror thing? Yeah, some of you. And that's only possible because Winnie the Pooh is in the public domain now. One important thing to note is that even if the character is in the public domain, newer works starring them may still be under copyright. So Sherlock Holmes is in the public domain. However, the newer Sherlock Holmes stories are still under copyright by the Doyle estate, meaning that you can use Sherlock Holmes, but not those elements of his character that are in the newest stories, which is a really weird situation, but that's the way that the copyright law works. In addition, works can be voluntarily released into the public domain. And let's talk a bit about that. You may have heard on the internet or elsewhere that copyright owners have to enforce their copyright or they lose it. However, the Supreme Court has held that copyright owners have no duty to challenge each and every actionable infringement. Copyright abandonment is a thing, but it's more rare than you think. It requires intent and an overt act to surrender the copyright. So inaction against enforcers, against infringers, is not enough. Trademark is a bit different, but again, it's something that we don't have time to get into today. And of course, we do have to talk a bit about AI, as we noted earlier. Works produced by AI are not eligible for copyright. What you might be wondering is, do works produced by AI infringe on the original material that they were trained on? And the answer is possibly. There was a federal district court decision recently that held that AI training on books was a fair use. We talked a bit about the test earlier. However, the company also used pirated copies of those books for the training, and that piracy was copyright infringement, so that case is still going on. There is another lawsuit right now about whether an AI company can be liable for indirect contributory infringement for enabling copyright infringement of song lyrics. That case, again, is still going on. The law is developing really fast in this area, so I'm sure this slide will be very outdated before too long. So that is our section on copyright, and just a quick quiz to review. Your friend asked if you want to buy a t-shirt with a picture of photographer Hololive on it. You ask friend if they have permission to use the picture, and they say they downloaded it from the internet, meaning it is in the public domain. Is your friend correct? No, they are not. Copyrighted works don't become public domain just because they're online. Abandonment requires the owner to intend to surrender the copyright and to take overt action to do so. Also, coverage does not allow commercial use of the IP, so there is that as well. So that's copyright. Let's talk a bit about contracts, including contract termination, some form of contract terms, arbitration, NDAs, non-competes, all that good stuff. So what is a contract? A contract is essentially a legally binding enforceable agreement between two or more parties. There's a few elements of the contract that have to be met, such as offer and acceptance, meeting of the minds, did both parties intend to form a binding legal relationship? Now, one example of a contract I know all of you have seen is those terms and conditions you have to agree to when you install an app or a program or use a website. And you might be wondering, is it actually an enforceable contract? The answer is usually yes, but it does depend a bit on the facts, on things like whether it was essentially a forced contract of adhesion, whether your use of the work was actually conditioned on the contract terms, things of that nature. Another element is defined terms. The subject matter parties and so on have to be defined clearly enough to know if the contract has been breached or not. There's also consideration. Was value exchanged both ways? That can be anything of value, money, promises to perform, but a purely gratuitous agreement, an agreement to give a gift for nothing, is generally not an enforceable contract. Next is competency. Do both parties have the capacity to contract? As in, are they not minor, not impaired? If a person is entering a contract on behalf of their employer, do they have capacity, do they have authority to speak for their employer? And finally is legality. You cannot contract to do something that is illegal, although most contracts have what's called a severability clause. If any part of the contract is illegal, then the legal parts of the contract continue in force and effect. One thing to note is that contracts do not necessarily need to be in writing unless the statute does not applies. Oral contracts are a thing, but usually not advised for what I hope for obvious reasons. So what happens if there's something that's not written in the contract? Well, typically courts do not read language into contracts that was not intended by the parties. And many contracts, certainly all of mine, are explicit about this. They contain a merger clause stating that nothing outside the contract is binding. So let's say you're in a contract with someone and they say in an email they'll do something, but if it's not actually in the contract itself, then it's not something that's enforceable. There are a couple of exceptions to this, such as incorporating outside documents, which become part of the agreement. Or in some cases, courts can consider contextual evidence about the parties' relationship if there's a question about how to interpret it. But those rules do vary a lot state by state. Now, for contracts, one important term is the subject. And of course, contracts should be pretty specific about what work is or is not included. I have been in cases where there's been a question about whether this or that item of work is compensable under the contract, and those are no fun, so you want to be clear up front where everybody stands. Contracts should ideally be clear about the nature of the deliverables, what format, dimensions, and so on. Contracts may also have a changes or approval process. That's especially important for things like, say, art commissions. What kind of changes can be requested? How many changes? Will changes add time or money to the contract? How much? And finally, one type of contract I've used is phased contracts, where if you're not sure about if you want to continue the relationship with someone, you can agree to do preliminary work and allow the contract, but not require it to be amended for the remainder of the work. Now for my favorite part, the contract payment. There are many factors that go into negotiating and agreeing on a contract price. Those include commercial use, intellectual property rights, exclusivity, the length of time to perform, and so on. There's many methods of payment under a contract, but for the variable pay structures like hourly, percentage, and so on, sometimes contracts have a minimum and or a maximum contract payable. And I actually have run into a contract maximum before where I had a consultant who went over their contract maximum cap, and I had to tell them, sorry, not to exceed means not to exceed. We can't pay for those hours that are worked over the maximum payment amount. I mean, if they told me earlier, hey, you need to raise the contractual maximum, we'd be having a different conversation, but you have to give it back to the maximum. Another payment term that some people sometimes overlook is who has the responsibility for any taxes that are owed for the contract work. Is a contractor allowed to ask for an adjustment to compensate for any taxes they may owe? And finally, contracts typically don't allow for payment for work done before the contract became effective. I never direct or authorize any contractor to do any work before the contract is signed. Because if they do some work before the contract, then we get into potentially some really messy, what's called quasi-contract situations. Another important factor in a contract is the timing. The contract should be specific about what is delivered by when. For example, if you're commissioning art for something that's really time sensitive, you want to have a specific delivery date, preferably with some float or extra margin before the deadline. Contract deadlines can also be changed later, but it is important for the parties to be on the same page, at least have a general understanding of the time frame from the beginning. Another important timing term is invoices. Assuming it's not one lump sum payment, how often and when will invoices be submitted, how much time is allowed to check and pay the invoice itself. Another important term in contract is risk management and indemnity. Contracts, after all, are a tool to control and allocate risk. A lot of contracts include provisions about how to handle any third-party claims, like some problem, harm arises out of the performance of the contract, and some third party sues. Typically, these risks be allocated to one side or another using indemnification, using defendant clauses. Let's say that I hire you to fix my roof, and your employee working on the roof slips and falls and sues both of us. Which one of us would have the risk? And typically, risks should be allocated to the party that's in control of the risk. So that would be the employer of the employee who fell. Now, risks between the parties, that's a bit different. Indemnification, having the other party indemnify you for your own negligence is very disfavored by the courts. So risks between the parties are handled instead using what's called liquidated damages, which is the parties agree in advance that if a certain type of breach occurs, some fixed damages that must be reasonable will be owed. So if A fails to meet the delivery date, A agrees that they'll pay B liquidated damages of X dollars per day till the work is completed. Now for disputes. Unfortunately, disputes do happen, and you really want to have understanding as to how those will be handled before the dispute arises. Many contracts have what's called alternate dispute resolution clauses that include arbitration, which is hiring an arbitrator, like basically a private judge, to hold something that's like a trial, but not quite. Arbitration decisions are binding and almost always final. It is possible to have a court overturn an arbitration decision, but it's very rare. It's a very high standard. Arbitration is often used because it can have cost savings over going to trial because appeal is so restricted. However, arbitration fees can be very high on the front end. I have personally worked with arbitrators who charge between $250 and $1,000 per hour of hearing, plus the time to write the award. And you may have heard of arbitration because those terms of use agreements that you agree to without looking at them almost always have an arbitration clause in there. And arbitration clauses are typically enforced, but there are some exceptions. Different from arbitration is mediation, which is where the parties, again, hire a neutral third party, but the mediator does not have any power to bind the parties. They're just there to be a go-between and help the parties come to a negotiated settlement. And if it does go to litigation, most contracts will include a venue or choice of law provision. If there is a lawsuit arising under this contract, where will it be brought? What laws will apply? Another type of contractual term you might have seen, heard around is non-disclosure agreements and non-competes. NDAs involve parties' agreement not to disclose certain information. Non-competes are agreeing not to work in a certain field, in a certain area for a certain time. And the enforceability of these varies a lot. For example, California does not recognize most non-compete agreements. In addition, general contract defenses may apply, which is something that requires a local attorney. And importantly, the rule against illegal contracts, remember that still applies. So an NDA cannot override statutory whistleblower protections. So this is contracts, and again, we have a quick quiz to review. You and your friend are drinking and complaining about your boss. Your friend is very drunk and says he'll kill your boss for you. Is this an enforceable contract?
Yes.
Get out of here.
In a perfect world, maybe.
No, it is not. Your friend was drunk, so no capacity to contract. You do not promise anything to your friend in return, so no consideration. And finally, murder is illegal. So, now that you've gotten a little information about the law, you might be wondering, when do you need to get a lawyer? And you know, sometimes you don't, right? I mean, sometimes people say they need a lawyer, but what they really need is an accountant or a communications or PR person. But some situations do call for lawyers. So just suing, being sued, drafting or reviewing contracts, incorporating certain regulatory filings, decisions that involve significant risk or potential liability. If the other party has a lawyer, there's a joke my friend told me, which is that lawyers are like snipers in video games. If the other side doesn't have one, you might be okay. But if the other side has one, you probably want one yourself. And finally, and whenever you'd be more comfortable with a lawyer. So if you decide you do need a lawyer, definitely don't rely on the other side's lawyer. They have no duty to represent your interests. Instead, you can consider using your local state bar's referral service. You can consider a pro bono clinic at like a law school or a bar association. Though those are usually means tested, you have to make it below a certain income, and they mostly specialize in doing stuff like family law, landlord-tenant. However, there are organizations like Volunteer Lawyers for the Arts, which is a really great organization that does a lot of pro bono work for artists. You can also, if you have used a lawyer before, ask if they know any lawyers in the relevant specialty. You never know. Okay, so you decide you need a lawyer. How much will this cost? Well, some lawyers do charge a fee for consultation. That is their compensation for the time to meet fee for checking for conflicts. Attorney rates vary quite a lot, but you can expect to pay $250 to over $1,000 per hour, depending on the level of experience, specialty, location, and to think I'm doing all this for a Sakura-Con badge. I recognize this is a lot of money, but depending on the type of case, some lawyers may take cases on contingency, meaning they take a percentage of any recovery that you might get, or if there's attorney fees available, like say in an ADA lawsuit, or some firms do offer payment plans. But wait, if getting a lawyer is so expensive, can't I just use AI? Well, there are a few reasons not to do that, which is that AI, LLMs, depending on the model, well, a lot of them do have the tendency to hallucinate, make up facts, make up legal citations, which turns out judges do not like. And if your judge is not happy, you will be even less happy, so don't do that. Another reason to be cautious about AI is that anything you input into an AI is not private, not confidential. The AI could reveal the information entered as a prompt. And AI is not an attorney, so attorney-client privilege does not apply. Anything you discuss with an AI can potentially be obtained by the other side in discovery, which may turn out to be embarrassing for you. So, that concludes my presentation, but we do have some time for questions, and I do have to ask again that you keep questions general, as this channel is not legal advice.
Earlier on, we were talking about specifically the CoverCore lawsuit.
Yes.
I know that we haven't really gotten to the point where this is going to be legal tested yet, but where would it, in a certain situation, especially with like the larger corporate VTubers, would you stop entering character design copyright law? and enter celebrity rights law?
You know, I'm glad you asked that because I would think that potentially, again, I think the copyright claims do have potential fair use defenses. I think depending on the specific content of the clips, which I haven't seen myself, defamation or right of publicity might potentially be a stronger claim, but again, the case is ongoing, and discovery may well turn up facts that lead to other claims coming up. Thank you.
Hello, I had a question about the lawsuit against Google Images.
Yes.
It felt very different from basically any other sort of copyright, I guess, standards.
Mhm.
Like, if I said, well, they made this official art and they turned it into a charm and they're selling that.
Right,
I'm gonna take this official art and I'm gonna turn it into a sticker.
right.
It feels kind of the same level of transformative of full-size image to thumbnail.
Right.
And a sticker doesn't substitute for a charm, but I know I would not get away with doing that. So I was curious if there were any other kind of details about that suit that kind of explained why it felt like they were giving Google that kind of, sure, a thumbnail is super transformative.
Now, it is a really interesting case, and the court's reasoning in that case was that the purpose of the thumbnail is not really to substitute for the full-size image, but to be a pointer that helps people find the websites. So, you really focused in on the social benefit of Google in general, if that makes sense.
I see. So my sticker is not going to like help anyone necessarily. It's not going to get the same kind of easy out.
Well, you've raised an interesting question, which is that there is something we didn't cover earlier, which is first use doctrine. If you own a work legally, you do have some ability to kind of physically transform it. Like if you legally own a picture, you can glue it to a tile, and that's not a copyright infringement because you already legally own the work. So let's say if you have a work that you own legally and I don't know, you have a badge maker and you make it into a badge, and that might be covered by first use, but it's really interesting and complex area.
Gotcha. Okay. Thank you.
Mr. Moore?
Can you go back to the slide with the Miku Artist Alley page?
Yes, I can. That was,
Yeah, that one. So I was wondering if you could elaborate on the word towards the bottom, commercial.
yes.
Would you say a lot of the Artist Alley vendors here would be considered commercial selling? Because I would assume most of them have to have a small business license in our state. I'm not sure how that works.
So, commercial is one of those words that's used a lot, but the meaning can vary a lot by context. So, from a risk management perspective, I'd say commercial is whatever cover believes to be commercial, but they do specifically allow certain uses of their work for money, like through the Hollow Indie cover. Wrong choice of words. Through the Hollow Indie label, cover does allow and recognize certain fan games using their IP.
Okay, so it's kind of almost on a case-by-case basis on what they would consider commercial selling of their works.
Yes, and it also has to be taken in context of the fan work culture in Japan, which, as I'm sure many of you know, there's a large doujinshi fan work culture in Japan, and a lot of works that may technically be infringing, a lot of fan works that are overlooked, let's say, by the creators, so long as they don't publicly embarrass, cause trouble for the rights holder.
Mm-hmm. And then just to kind of leave that statement here, because I do know a couple years back, this convention specifically, a lot of the industry folks did not want the fan artist vendors in the same area as the official works, because I think they were worried about copyright and infringing and not wanting to have their people purchasing fan works thinking they were official. There was that worry, I think.
Right, and that crosses over into trademark as in the source of a work. They don't want, basically, they don't want people buying fan works thinking that they're official.
Yeah, okay, thank you. Yeah.
Sure thing.
When it comes to pieces that whose origins are like unclear, like say a lot of American folk songs that are
Mhm.
really old. How's copyright handled for them? Does it, is there protections to that, or does it go to like the first person who made the recording?
Interesting. So, in the case of works that are in the public domain or basically abandoned, the recording of a song, a particular performance recording of a song, may have a separate copyright from the composition. So, for example, there's a lot of classical music on YouTube, and of course, the songs themselves, the compositions, are in public domain because the creators have been dead for centuries. But a particular performance of the song, this performance of Beethoven's Ninth by this orchestra on this day, that may be under copyright.
I have one more question, I
Oh,
apologize.
yeah. No worries.
One of the big things that was mentioned earlier, and I've experienced this personally firsthand, when it comes to like a VTuber where there are multiple different works coming together to create the whole, right? You have potentially an illustrator, a rigger, the actor or actress. Where would, like, at what point do there become too many rights holders in play to be able to specify, like, to be able to pick apart what could and couldn't be under a specific protection?
Now, that's a really interesting question, and because the field of VTubing is so new, there isn't really a precedent for this. But certainly, anything that's eligible for copyright, which, as we discussed earlier, isn't a particularly high bar, just has to meet the originality, expression, and so on. So things like the design itself, the rigging, the voice work could potentially be subject to different copyrights in the same way that the composition, lyrics, recording of the song might all have separate copyrights. So these issues can get messy pretty quickly, is what I'm saying.
Is rigging specifically a copyrightable work? I don't know if it's treated like fonts, where it's the designs aren't, but the software is, or if it's something else entirely.
That is another really interesting question, because rigging, as you pointed out, has certainly some functional elements. I mean, the model can't function without rigging to it, but it might also have some creative elements, right? Because, I mean, dance moves, martial arts moves could in some cases be copyrighted.
Mhm.
If you're posting art on social media, are there anything you should do to protect both your rights and yourself from getting sued in terms of like maybe some disclaimers or watermark or whatever? Is there any advice you can give?
Well, I can't give legal advice in this presentation because I'm not your lawyer, but as a general matter, when posting fan art on social media or in other places, I think one really good way to manage risk is, as mentioned on this slide, paying attention to any rights, any FanWorks policy that may apply. For example, the original rights holder may allow certain FanWorks to be made under certain parameters, and if you're within those parameters, then generally that would be a good way to manage risk.
Thank you.
Yeah, no problem.
Hi.
Good morning.
Morning. So Team Shanghai Alice, they have a FanWorks policy,
Yeah, they do.
3 different languages,
Yep.
and they're all updated at different times, and they all say different things. If I were going to use a FanWorks policy and there's all those languages, what would a court generally consider? Would they look to the language that's in my language, or would they look to the most up-to-date one, or would it be up to Team Shanghai Alice, if they were going to sue me, to determine which of those works might be considered in the legal defense of my infringing of their copyright?
This would be what we lawyers refer to as a cluster. I'm not going to finish it because this is a C13 plus panel. When I write contracts, and if they do need to be made available in more than one language, I always have something in there that states which one is the official, I guess, document. We might say, this translation is provided as a courtesy, but in the event of any conflict, then the original Japanese or English, whatever the case may be, would prevail.
So are they then maybe weakening their legal defense by not keeping them all consistent?
I think to the extent there are inconsistencies, that creates confusion, which is, I mean, against the point of having a standards policy in the first place. Yeah, okay.
I'll talk to Zoom.
You do that. Get back to me. Good morning.
Good morning. This may fall under advice rather than a more general thing, but say you're somebody who has a contract for a service such as commissions.
Yes.
Is there such a thing as like a general contract where you would substitute like a commissioner, commissionee for like across a bunch of different uses? Or is this the kind of thing where it's like you may want to ask a lawyer to draft it individually for every single use?
Can I tell you a secret? A lot of the contracts you see out there are largely copied and pasted from other contracts that the attorney or firm has worked on. So there's certainly a lot of standardized language out there. There are services that offer template contracts. I don't know that I can ethically necessarily recommend any of them, but they are out there, and it is potentially an option to consider.
Thank you.
Yeah, sure thing.
Hello.
Good morning.
Is there any law against like making animated versions of real like real human videos? Like so, for example, I have some instructions
Mhm.
to do a crochet probably,
Yeah.
and then if I make an animated version of it, and then like make money out of it, is there like any legal issues about that?
So generally, an animated version of a real-life video will be considered a derivative work of that video. It's a new work that takes elements from the original, and that could potentially raise some copyright issues. Fair use might apply depending on circumstances. It's a very fact-dependent question.
So how about I use it in another country? Is that
International copyright, that's a fun one. So that raises Berne Convention issues. Basically, any signatory to the Berne Convention has to provide other countries that are part of that with the same copyright protection they provide to their own people. So there is possibility for international copyright issues, is what I'm saying. Yeah, sure thing.
Hi, I'm currently a 2L. I wanted to, like, especially seeing that you're a lawyer, I just wanted
Yes.
to get some like general advice for like, a law student in general.
Okay, well, that's an interesting one. In terms of advice for law students, I would say that one thing that's really important, and especially in a job market like this one, is getting practical experience, like doing clinics, doing interesting summer work. That's something that I think employers really like to see. Do you have any specific questions about that?
Yeah, mostly for someone like me who's into IP law, especially copyright and trademark.
Okay. What I will say about intellectual property is that at most firms, most of the IP work is patent. That's where the big money is. And copyright and trademark are kind of lumped onto that. So to the extent that you're able to get some patent work, and having a science STEM type undergrad helps. It's not required, but it helps. If you can get into patent, that would be helpful in pursuing an IP career.
So like something like patent litigation and then like using those skills to transfer into like something like trademark and copyright.
Patent litigation, patent prosecution, things of that nature.
I mostly ask about litigation because I don't have that hard science background.
In that case, patent litigation is probably a better path.
Okay. Thank you.
Yeah, sure thing. And I do see that it is 11. So that's all the time we have. But I do want to note that here's my credits, sources, and I recognize it's pretty small text, but the presentation will be available on my socials. You can scan the QR code there. Also have to give a quick shout out to a fan event for the VTuber group Incense EXE. It is happening this afternoon at the Happy 11. I contributed some art to it. There are great people doing that event, so check it out if you like. And otherwise, thanks for coming out and enjoy the rest of your con.